Duncan v. Louisiana. The facts. Duncan was convicted of simple battery in Louisiana. Under Louisiana law, simple battery is a misdemeanor, which is punishable up to 2 years in prison and a $300 fine. Duncan sought a trial by jury, but was denied because Louisiana only grants jury trials on capital punishment cases. Duncan was convicted and sentenced to 60 days in prison with a $150 fine. He appealed the denial of his jury trial, but the Supreme Court of Louisiana denied the writ, finding there was no error. So what is the issue? Whether the 6th and 14th Amendments guarantee the right to jury trial in state-level criminal cases where sentences are punishable by up to 2 years. In a series of cases, the Supreme Court, under the 14th Amendment's Due Process Clause, started to apply fundamental rights guaranteed in the Bill of Rights against the states, which is known as the doctrine of selective incorporation. The rule of law: the 14th Amendment guarantees the right to a jury trial in all criminal cases that come within the 6th Amendment's guarantee. The court noted the following test for determining whether a right extended by the 6th Amendment in federal criminal cases is protected against state action by the 14th Amendment. A, whether the right is fundamental to liberty and justice. B, whether it is basic to our legal system. And C, whether it is a fundamental right essential to a fair trial. Duncan claims that the right to a jury trial guaranteed by the 6th Amendment meets this test. Louisiana, on the other hand, argued that the Constitution imposes no duty on the states to give a jury trial in any criminal case, regardless of how serious the case is. The 14th Amendment denies the states the power to deprive any person of life, liberty, or property without due process. Many of the rights guaranteed by the first 8 amendments have been held to be protected against state action by the Due Process Clause. The 6th Amendment guarantees, among other things, the following rights: the right to counsel, the right to a speedy and public trial, the right to confront opposing witnesses, and the right to obtain witnesses. By the time the Constitution was written, jury trials in criminal cases had existed in England for several centuries. Included in the Bill of Rights was the 6th Amendment, which provided the following: in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. The original states adopted the guarantee of a trial by jury. Every state entering the Union thereafter protected the right to a jury trial. The purpose of the right to a jury trial is to make judicial unfairness less likely. Louisiana also argued that the conviction was for a misdemeanor. The court, however, was not persuaded. While petty crimes are not subject to jury trials, the penalty authorized is relevant in determining whether it is serious or not. Louisiana made simple battery punishable by imprisonment by up to 2 years. The question then is whether a crime carrying such a penalty is a crime which Louisiana may hear without a jury. The court obviously answered in the negative. The Supreme Court held that the right to a jury trial is fundamental to the American criminal justice system. The 14th Amendment guarantees the right to a jury trial in all criminal prosecutions for serious offenses. However, the court made no distinction between petty and serious crimes, but noted a crime punishable by 2 years is enough to be serious. As a result, Duncan was entitled to a jury trial, and it was a mistake to deny it. Justice Harlan dissented, writing that the states could design their own systems. The states have always borne primarily responsibility for operating the machinery of criminal justice within their borders. The Due Process Clause of the 14th Amendment requires that those procedures be fundamentally fair in all aspects. It does not, in my view, impose or encourage a nationwide uniformity for its own sake.